Hello again to everybody. I hope you had a lovely lunch break, and we don't skip a beat and move straight on to the next layer of legal arbitrage in corporate finance or finance. And that topic will be presented to us by Felix Steffek, who teaches at the University of Cambridge. And he will present on the topic that I believe, Felix, has been research interest of yours for a couple of years now already. Commencing corporate insolvency proceedings at the right time, directorial responsibility in financial distress in the UK, the US, and Germany. So a legal comparison that may, in due course, lead into critique of legal arbitrage as well. Felix, thank you for chiming in, and I hear you have just business to attend to at Cambridge. We are very thankful for you to make the time anyway, and the floor is yours.
Yes, so thank you very much. It's really a great pleasure being with you. Of course, I would much rather be with you in person in Vienna. The reason why I can't be with you in person is that I'm currently serving as deputy chair in my faculty, and there are meetings that I need to attend in Cambridge, and that's why I'm missing out on the beautiful city and the surely lovely community that you have in Vienna. I'm really grateful for the invitation to speak, and in particular, grateful for accepting that I speak online. As you said, I'm presenting on commencing corporate insolvency proceedings at the right time. I'm in particular interested in the role of directors in financial distress, and in the keeping to the theme of the conference, I'll focus on the UK, the US, and Germany in comparative perspective. What will I present on? First, I would like to present some context and the economic problem, and then I would like to use the residual claimant principle as a principle to capture the problem and develop solutions. Then based on that, I'll present legal strategies that both private and public ordering uses to solve the problem at hand. I will then show that private ordering and credit decision rights do not solve the problem sufficiently, which then justifies the need for public ordering. And then I'll look into what the UK, the US, and Germany are doing there, and we will find that they are actually taking different approaches. So first, context and the economic problem. So I'm focusing on financial distress, which I define as the breach of a financial obligation of the company, and we're only looking at the time before insolvency proceedings are opened. Now, in this phase, even though we are in financial distress, directors still answer to a shareholder-centric governance. That is, even if the shares are valued at zero, shareholders are still the ones appointing and removing directors, giving decisions, and creditors, even if now the residual claimants do not enjoy statutory decision rights. What do I have in mind when I talk about residual claimants? I'm referring to the residual claimant principle, where we define the residual claimant as the claimant still having a valuable claim against the assets of the company, but being the last to claim. And as a result, that claim will be variable. In other words, if the company is more successful, the claim will be higher, or the value of the claim will be higher. If the company is less successful, it will be lower. Now, I'll go into the residual claimant principle later in more detail, but I'd like to point out at this point that the core idea is that the residual claimant, being the last one to claim, but having a variable claim, has the best incentives to maximize the value of the assets, because that claimant benefits the most. And therefore, that claimant, so the narrative goes of the residual claimant principle, should have the ultimate decision rights. What is the problem that we're looking at in terms of directors in financial distress? I think I can keep this really short, in this environment where everyone is familiar with it. Directors and shareholders are not liable for the company's debts in insolvency. However, creditors suffer from asymmetry of information and interests, where directors have more information and partly interests differing from creditors' interests, leading to value losses that affect creditors negatively. What are some examples for that behavior? Directors withhold information, leading to creditors being in an undesirable bargaining position. They may linger for resurrection. That means directors being interested in maintaining their position may just keep going, even though continuing to trade in financial distress is ultimately value destructive. They may engage in excessive risk-taking, according to the thinking, well, we are anyway out of the money, then let's risk the little money we have left. And if it works out, we are back in solvency. And if not, nothing is left. Or even worse, engaging in diverting assets out of the creditor's reach. These incentives can probably be identified as conflicts of interests. But in addition, there are kind of even well-meaning directors may harm creditors because they suffer from decision deficits such as over-optimism, illusion of control, and selective perception in financial distress. So that's the context and our economic problem. Now, I'd like to use the residual claimant principle to shed some light on this. What is the governance structure we're looking at? So I'm framing the issue as a governance topic. Now, before formal insolvency proceedings are commenced, and under insolvency proceedings, I understand both liquidation proceedings and restructuring proceedings, there is a shareholder-centric governance in place. As mentioned, shareholders appoint directors, remove directors, and they hold decision rights, whereas creditors do not have statutory governance rights. This has been reconstructed using the residual claimant principle, under which the ultimate decision rights should lie with the residual claimants. Now, in the solvent firm, the residual claimants are the shareholders because they have access to the profits of the company, and these profits are variable. So the more profitable the company is, the more profits will go to the shareholders, and the less, making this the last claim, because creditors are paid first, but a variable claim. So we are looking at shareholders as the residual claimants in the solvent company. And then, as mentioned already, as a result, because shareholders are now best incentivized to maximize the value of the firm, they should hold ultimate decision rights, which in fact they do in the solvent company. And I've just described that. Now, following this logic, once the company is in financial distress, and we can be a bit more precise here and identify this as a state where the liabilities of the company exceed the assets, then the creditors are the residual claimants. The shareholders' claim has a value of 0. Now it's the creditors who receive the remaining value, and that claim is variable because we are in a situation of over-indebtedness. Now, interestingly, all jurisdictions do not follow the residual claimant principle strictly. Instead, there is a phase before the formal opening of insolvency proceedings where a shareholder-centric governance remains in place, even though the creditors are the residual claimants. Now, if we would apply the residual claimant principle strictly, we would say once the company is over-indebted in the sense of liabilities exceeding the value of the assets, the company should immediately turn to a creditor-centric governance. However, if we look at the US, Germany, and the UK, we find that that is not the case. So there's no strict application of the residual claimant principle. Why is this the case? The reason is that when the asset value is just a little below the sum of liabilities, the value of the assets is still higher under debtor control than it is under creditor control. And why is that the case? The reason is that the creditor's upside is limited. Now, if we would now just after the company becomes over-indebted, if we would immediately turn control to creditors, they would just be interested in bringing the company back into solvency. However, they would not actually be interested in maximizing the value of the assets. Why? Because all they need is to cover all liabilities with the value of the assets. Instead, shareholders' upside is unlimited because their claims are not fixed as the creditor claims. So as a result, actually it is shareholder control that is still promising higher value for the company's assets, even though the company is over-indebted. However, if we now look at the development of asset value over time, assuming that things get worse, there comes a point where the expected value under debtor control is now lower than the expected value of the assets under creditor control. And as this is the right point then, within that logic, where the governance rights should switch to the creditors. Interestingly, and I'll go into that later, there is actually no comparative consensus when this is the case. I'm just referring to English law here, where we find in the statute, that is section 214, that the relevant point in time is the moment when there's no reasonable prospect that the company would avoid going into insolvent liquidation or enter insolvent administration. Now, following on, or kind of developing the quest to identify the right moment when governance rights should switch from shareholders to creditors, we need to differentiate between restructuring and liquidation proceedings. Why? Because if we differentiate them, we see that their opening, and that means opening means transferring decision rights to creditors, that is, starting a creditor-centric governance instead of a shareholder-centric governance, they differ in terms of the value they create or destroy, depending on whether they are opened too early or too late. So what I will do now, I will, applying the residual claimant principle, I will take a look at what a too early or a too late opening of a restructuring proceeding as opposed to a liquidation proceeding will have as an economic consequence. I'll start with restructuring proceedings. If we think about what happens if a restructuring proceeding is opened too early, then a procedure will be triggered. However, that procedure will usually lead to a realization that actually there is no case for a restructuring. That is, there will not be any reduction of claims, there will not be any lowering of interest rates, and there will not be any extension of due dates for payments. So the result is that an too early opening of restructuring proceedings triggers procedural costs, but that's in most cases all there is. What happens if a restructuring proceeding is opened too late? Then restructuring value is lost. In the worst case, the restructuring is not possible anymore. And that value loss is relatively higher than the procedure costs that are triggered if the restructuring proceeding is opened too early. Now, what do I mean with too early or too late? Too early or too late refers to the difficulty for the stakeholders to actually identify the right moment in time. That is, the moment in time in which a switch to creditor control maximizes firm value over staying with debtor control. So I conclude here that a false negative in terms of opening restructuring proceedings too late is more costly than a false positive that is triggering such proceedings too early. And I conclude that in doubt, restructuring proceedings should be opened too early. And in doubt again means refers to the difficulty of determining the right moment in time. In other words, determining the future asset value under that proceeding. Now, moving on to liquidation. What happens if a liquidation is triggered too early? Then restructuring value is lost, because what happens then is that instead of restructuring the business, which is still possible, a liquidation proceeding is opened, which is too early, is actually not necessary. And so the restructuring value is lost, which is significant. Compare that to opening liquidation proceedings too late. All you lose then is the liquidation value. So the liquidation value that you would have had you opened earlier. Now, with liquidation values usually being quite low, I would argue that all in all, losing the restructuring value by opening too early destroys more value than opening too late. So with liquidation proceedings, it's the other way around. Here, a false positive is more costly than the false negative. And that means that in doubt, we should open liquidation proceedings too late. Now, just looking at the UK for now, English law actually conforms with these findings, because the UK or English law has restructuring proceedings that can be triggered very early. In fact, there are proceedings that can be triggered without an insolvency ground necessary, allowing very early opening. So opening restructuring proceedings with a low threshold. Opposed to that, liquidation proceedings are mandated to be opened quite late, because the trigger, in terms of the trigger of getting directors to act under Section 214, is that of no reasonable prospect. And if we look into case law, this is really, really late. Now, I'd like to turn to the legal strategies that legal orders can use to deal with the issues at hand. So the issues at hand are opening the proceedings at the right time, but also dealing with the risk that persists during the phase of financial distress, where shareholders and directors are still in control, even though the creditors are now the residual claimants. What do legal systems do? Both private and public actors, or by way of private and public legal ordering, try to strengthen the creditors as outsiders against the insiders, directors and shareholders. What's the aim? I would posit that the aim is commencing restructuring and liquidations at the point in time at which the expected value of the asset is maximized. And I've just tried to identify that further. And in addition, but I'm less interested in this presentation, prevent directors from undesirable actions and compensate creditors if they occur, and in particular avoid transactions that disturb the collectivity of enforcement. So these are the side aims in terms of protecting creditors during the phase in which directors are still in control, even though the creditors are residual claimants. What is the legal framework of strategies that we find? I think we find 5 legal strategies that are commonly used, or that, well, in other words, or perhaps more precise, legal strategies that can be used. First, decision rights to commence restructuring and liquidation proceedings. Second, incentives to act in the interest of creditors. Third, constraints to minimize the cost of debtor control. Fourth, avoidance of transactions. And fifth, information rights and duties. As mentioned, I will not go into detail in all of these. Instead, I'm interested in the legal strategies focusing on commencing restructuring and liquidation proceedings at the right time. First, I think it's useful to look and ask whether private ordering and creditor decision rights would solve the problem. Why? Because if that is the case, then solving the problem can be left to private ordering or private decisions, and public ordering would not be necessary. However, that does not work. Creditors are not able to write perfect contracts. Why? First, we're looking at a future problem. So we're looking at credit and the future inability to serve credit. And there's a high risk that the contracts that creditors and companies would write as regards opening proceedings and the point in time at which proceedings are opened would either be incomplete or overly restrictive. Also, there is a very significant collective action problem. There are creditor groups with different interests. Unsecured creditors would like to open early. Secured creditors might not be interested in that because they're secured. We're looking at a large number of creditors, and also creditors join at different times. So the question would be how that can, how that would factor into solving the commencement problem by way of contract. Also, there are creditors that cannot negotiate. Involuntary creditors, such as tort creditors, and non-adjusting creditors, such as consumers, will not be able to contract on opening proceedings. Now then, what all legal systems do in response is they provide creditors with statutory rights to trigger proceedings. And the key issues that legal systems have to solve are determining who has the right to open proceedings, at which financial state, and what kind of proceeding is opened. Now, looking at the UK first, we see that actually in terms of who can open proceedings, all three possibilities are used. That is, creditors can trigger proceedings, debtors can trigger proceedings, and even third party, and these are state institutions, can trigger proceedings under certain conditions. However, I would argue that these rights or options given to creditors to change the governance in the sense of triggering a creditor-centric restructuring or liquidation proceeding are not working. If we remember that the aim would be for creditors to identify the right point in which switching to a creditor-centric governance would maximize firm value over leaving a debtor-centric governance in place, then their problem is that as outsiders, they do not have the information to value the assets adequately. Instead, it's the insiders that have the necessary information. Also, balance sheet insolvency, as the insolvency ground that happens first, is an accounting insolvency ground or accounting-based insolvency ground. And that accounting-based insolvency ground does not trigger an external signal. So creditors as outsiders are often in the dark about what is actually going on in terms of asset value. So in sum, I would argue that we do need public ordering. What's the aim of such public ordering? As discussed, for liquidation and restructuring proceedings, the main aim is to open them at the right time. For restructuring proceedings, when the expected restructuring value under debtor control is smaller than the expected restructuring value under creditor control, and as explained, I think that should in doubt be too early. Liquidation proceedings should be opened when the expected value under debtor control is smaller than the expected value under creditor control, and here it's the opposite, in doubt too late. Then, as a side conditions that I'm not concentrating on today, value losses and deviations from collectivity should be avoided. Now, turning to what the three legal orders that I mentioned are doing, we actually find quite different approaches. So first turn to the legal strategy that I call director constraints. What does German law do? German law says if you have reached a certain financial state, balance sheet insolvency or cash flow insolvency, you as a director are ordered by law to file for insolvency. That is different in the UK. Here, English law says once there is no reasonable prospect of avoiding liquidation or insolvent administration, you have to act in the best interest of the creditors. So there's no express ordering of filing. However, quite often, filing for insolvency may be the only action that actually fulfills that order, in the sense of anything else other than commencing insolvency proceedings would not be in the best interest of creditors. The third legal order, the US, actually does not do any of these and essentially says, as a director, you need to continue to act in the best interest of the corporation, that is the shareholders. So what we see is that constraints on directors as regards the opening of insolvency proceedings are employed in different intensity in these legal orders. So in Germany, you find a strong form, a duty to file. In the UK, a medium strong form in the sense of a duty to act in the best interests, which may turn into a duty to file, but not express. And in the US, a weak form where essentially it is fraud only that protects creditors. Now, looking at the other legal strategies that are available, it is interesting to see that incentives for directors are only used in the sense of the incentive of staying in place. That is, directors are encouraged to commence debtor in possession restructuring proceedings because they offer to directors to stay in place. What we do not find in terms of statutory law is positive rewards for directors. Interestingly, as regards information duties, we do only find in these three legal orders bilateral duties. So as long as there's no formal insolvency proceeding opened, directors may be in a position where they need to disclose to an individual creditor, a potential future creditor, that there is financial distress, but they do not have a duty to make such financial distress public. And I find it quite interesting to think a bit more about why that is the case. So at this point, however, I conclude. I've tried to show that the residual claimant principle is a useful framework to capture the problem and solutions as regards when restructuring and liquidation proceedings should be opened. The residual claimant principle explains and reconstructs what we find in legal orders, that is that the upside limitation of creditors and the unlimited upside of shareholders explains why we do not immediately turn to a creditor-centric governance when assets are lower than liabilities. Now, investigating this further, we see that due to contracts being imperfect and decision rights not being ideal for creditors to be exercised, there is a need for public ordering of the responsibility of directors as regards commencing proceedings. I try to show that the aim of public ordering would be to trigger restructuring proceedings too early, in the sense of uncertainty as regards the asset value, and trigger liquidation proceedings in doubt too late. Now, looking then into the legal orders, we find different approaches. That is, different intensities as regards constraints. We don't find positive rewards. Instead, we find the reward or the incentive to stay in place. And we find only bilateral information duties. Now, with this, I conclude, and I'd be interested to discuss. And thanks again for having me and allowing me to present online.
Yeah, thank you, Felix. I hope you could hear the applause you just got. We are open for questions.
I'm there, actually.
As you wish,
Yeah.
of course.
Hi, Felix. I don't know if you can see me. Great presentation. I really enjoyed it, and sort of also very close to my heart. So the idea of creditors and insolvency proceedings. I guess I have two comments and one question more. So the first comment is on the story about upside and creditors not being interested in value maximization, if I understood you correctly. I wonder if it's worth thinking about some types of creditors, so differentiating some creditors who are actually interested in value maximization. We see some types of creditors who are, for example, bargaining for debt via EBITDA participation agreement. So this is debt which is linked to a firm's performance. So you can have secured term loan, and you will also receive a quarterly fee, which is calculated as a percentage of borrower's EBITDA that crystallizes into a debt claim via what we call payment in kind notes. So it's essentially debt with upside, and in this type of debt, investors actually very much interested in value maximization, and it is an example of quasi capital, but it is debt, if sort of strictly speaking. The second point is more on your very interesting discussion about creditor-centric governance. I really like this term, but I was wondering whether we might want to differentiate here a bit more creditor-centric governance via, as you were saying, public ordering and statute, and creditor-centric governance via contract, because there are examples of creditor-centric governance. For example, if you're a debt investor and at the same time you hold golden shares, it's a sort of strategy that we have a lot in the US. Those golden shares, it's a debt investor who holds them also as a shareholder, but they essentially prevent you from filing for Chapter 11 bankruptcy. If you have these golden shares, the state-supplied bankruptcy regime doesn't apply to you, and you're in control of the company. So I was wondering, where does the governance via private ordering come in? And this question whether should legislator really follow up on this question? Maybe we can just leave it to private ordering. And the last point is more just a comment. I really like the residual claimant principle. There is literature by Elias and De Fontenay, and they essentially argue that in highly leveraged firms, debt providers are residual claimants ex ante from day one. So thank you very much. I'm looking forward to your answers, or you don't have to answer. It's just mostly like comments. Thank you. I really enjoyed it.
Thanks. If it's okay, I would answer right away.
Yeah, please do.
Thanks a lot. Thanks a lot, Narine. Great seeing you on screen. And so to the 3 points that you mentioned. So the first point you mentioned is, what about creditors that kind of start blending into, or kind of are more similar to equity? And that addresses an issue that I raise in the paper that I've distributed, but that I did not present here now. And that is, what if we start differentiating different classes of creditors, in terms of ranking higher or lower? And what I show in the paper, but that is only a preliminary argument, is that I argue that there is no immediate reason that would convince me that one should start differentiating classes of creditors, with the result that then only that specific class that is the residual claimant class would then have exclusive rights to trigger. So, kind of, if we start introducing different classes of creditors and you follow through on the residual claimant principle that I developed, one could have the idea to say, well, then we have, if we differentiate classes, then it is just the class that is the residual claimant at that moment in time that should now have the right to trigger. Why? Because their claim is variable, and therefore they have the best interest to maximize value. And so you could argue that other classes would not have the right incentives to trigger, because they may be fully in the money or fully out of the money. Now, the argument that I currently see against this is that it would be a quite risky strategy for a regulator to do so, because many of these classes do not have the information and the incentives to actually engage in triggering proceedings. So, think about, let's say, consumers, employees, tort claimants that would at some point be the exclusive holder of triggering rights. And so what I argue in my paper, but that is really a preliminary point, is that I currently think it would be a risky strategy to start differentiating further in terms of assigning triggering rights depending on the ranking of classes. Now, to your second point, that was on kind of, you asked the question whether kind of how far we should leave triggering rights and their assignment to private ordering as opposed to public ordering. And I think you indicated that there may be a case to leave some room to private ordering. And if I understood correctly, then I agree. Because first of all, that is exactly what we see in law or in statutory law. Statutory law, if you look into triggering rights, they are actually quite basic. So they are usually bound to triggering conditions. They're different for restructurings and different for liquidations, but they are actually quite basic. And in particular, they do not, something like I just discussed, they do not differentiate much between different creditor classes. Now, this instead is something that we find in private agreements. So if you look into intercreditor agreements, for example, we do see that sometimes it is only a specific class that is bound by the intercreditor agreement that has such triggering rights. So I do agree that it seems, at least empirically, we see that that lawmakers, public lawmakers, reduce themselves or kind of constrain themselves to basic triggering frameworks and leave more sophisticated frameworks to private ordering. And I think that is in line with other research that we see that argues that that governance rights are firm specific. So it would be a mistake for the regulator to impose a all size fits one triggering regime on all. Now, your last point, I'd just like to essentially tip that, where kind of you touched upon the issues like maybe, may creditors be residual claimants from the start? And that is something that I also address in the paper, but essentially in the sense of this is worth looking into. And that is the role that option theory can play in working out further details of the proposals that are made. And options theory in that case means that we have to think, or we have to differentiate between the position stakeholders are in or claimants are in at the moment of triggering a proceeding and the moment or the position they will be in at the end of the proceeding. And if we start doing that, then residual claimant positions become more liquid. Now, what I did, I applied a very static understanding of the residual claimant principle. So I just said, we look at the moment in time of triggering the proceeding. The reason why I did this is that it becomes very, very complex if we start to develop frameworks where we are differentiating residual claimant positions depending on the moment in time, differentiating the triggering of the proceeding and the solution of the proceeding or the end of the proceeding. But I think it's a very worthwhile exercise actually engaging with that more.
Thank you. Any further questions? Then I have one. Felix, do you have any evidence as to what the key, in the areas you looked at, what the key drivers of regulatory difference are? I mean, are those just genuine attempts of various legislators to find the most efficient solution, or are there cultural path dependencies? Is it driven by different business environments? What have you found on this?
I would say kind of this links into research, in particular in corporate insolvency law, that is has started but has not yet. There's still a lot of work to be done that starts to try and match governance frameworks to local conditions. And what are these local conditions? These are issues such as firm size, such as shareholder structures, such as institutional structures. And to give just one example, so I think it would be worthwhile, and that has already been done. So but it would be worthwhile connecting this more to what I presented, in the sense of asking how do shareholder structures in terms of dispersed shareholder ownership versus controlled blocks, how do they influence desirable regulation? And for example, you could develop an argument that the more you have controlling blocks of shareholders, the more you have an argument for a duty to file, because otherwise you have these unholy alliances between the block of shareholders essentially telling directors to stay inactive thereby harming creditors. So you could argue, if you find this convincing, then you would say, because Germany has more blockholders, therefore it does make sense to have a duty to file, because this strengthens the creditor position in a situation where these blockholders are very well organized and may otherwise force directors or kind of push directors not to file. Whereas in you could argue that in a dispersed position such as in the US, there's shareholders are less well organized, and therefore it does make sense to give directors more freedom. So in the US, we don't find a duty to file.
Okay, thank you. Just maybe one little follow-up as well. I mean, you're talking, and please correct me if I'm completely wrong on this, but your talk made me reconsider this entire residual claimant principle. And I would like to start with the observation that, technically speaking, shareholders are residual claimants in insolvency as well. Right? So it's, of course, it's just a theoretical scenario in which insolvency proceedings yield as much as to satisfy both creditors and shareholders. But there's, as a bedrock sort of ironclad principle, I think it's at least a bit imprecisely formulated. Aren't we gunning for something else really, rather than residual claim instead of? And is this maybe connected to the availability of debtor in possession or not? Because one other way of looking at insolvency is, okay, so business choices have been made. These choices did not stand the test of the market. And that's why we need to switch the decision maker. Are there maybe more simple approaches to insolvency than this residual claimant principle, which I feel is even conceptually a bit misguided?
Right. No, that's a really good question, and I think there are multiple aspects that I'd like to address. I think the first is that I use the residual claimant theory here in a way to essentially reconstruct law. So in the sense I applied it, and I essentially just tested the residual claimant theory against what we find. And so, in one way, you could argue that it's perhaps not terribly exciting to say that we don't trigger insolvency proceedings at the right moment in time when assets are lower than liabilities. However, I still found it interesting because the residual claimant principle brought this issue out very clearly that we don't do that. And it led me to kind of, I would say, a clear argument why we leave a debtor-centric governance in place, even though the creditors are now actually the ones with the last claim that really has value. Which leads me to the second point. Now, kind of you asked whether shareholders are not the residual claimants too.
Yeah.
And I think that depends on how we determine the residual claimant. If you take my perhaps simplistic or static approach, in which essentially at the moment in time in which you trigger a proceeding, you ask whether a shareholder at that moment in time will receive payment, then the answer is no. And then under this, admittedly simplistic and static definition of the residual claimant position, shareholders are not residual claimants. However, and I think that is why this is a really good question that deserves further inquiry. If you say, well, I determine the residual claimant not at that moment in time, but I ask what the potential future position
there you go, yeah,
that group after the conclusion of the right proceeding can be, then in some situations, shareholders who are out of the money in that situation, but would actually be back in the money after a successful restructuring, will then become future residual claimants. And this is exactly what a great short paper by Clarissa Boone and Tony Casey is doing. It's only on SSRN yet. So they are applying this theory, and they frame it as an option theory applied to the triggering of insolvency proceedings. And they then ask what follows from this if we apply this more dynamic definition of residual claimant. Now, personally, I found it really interesting and worthwhile. At the same point in time, if you have this very fluid, this makes the whole position of residual claimant more fluid, and therefore conceptually it becomes very complex in managing this in a pragmatic way that actually will work in practice. Now, final point to what you said. I think, if we think through how you can solve the governance problem at hand, then also I think what you raised in your question is the point. So what are alternatives? And I think one alternative that we see is that you can alternatively or additionally solve the governance problem via decision rights in the procedure. So essentially, like, when I went into, so what are the costs or what are the value that you can generate in a restructuring proceeding or in a liquidation proceeding, that will be mainly driven by who decides and what incentive that group has. And so, if you design voting rights in restructuring proceedings, you can probably solve a lot to counteract the triggering problem. So I think, if you look into what legal systems do, they actually focus on the triggering, and they also focus on the assignment of decision rights in the procedure.
Yeah, very good. Thank you. Thank you so much. If there are no further questions, let me thank you again, Felix, also for your Q&A. Thank you so much.
Thank you very much. It was a great pleasure. Thank you.